Well, good morning, everybody. Thank you all for coming. We have a good crowd, and I hope we're going to have a good discussion on 337. We're doing this first with the generous support of the firm of Okun, Gump, Strauss, Hauer, and Feld, because we see the use of 337 and the issue of protection of intellectual property becoming much more important as part of overall American competitiveness and part of American trade policy. You saw this as recently, really, as last week when the President came out with his Section 301 report, which was based on technology transfer, theft of technology, IP theft and forced technology transfer on the part of the Chinese. While there's been and will be more debate about the President's remedy, there's been really relatively little debate about the allegations, which I think are broadly agreed in the American business community as being both serious and accurate. And I think that's a reflection of the fact that as the trading system has changed, as global supply chains have developed, as the American economy has become more sophisticated, intellectual property really has been increasingly the key and the core element of American competitiveness. We are not any longer the lowest cost manufacturer of everything. And the key to our success continually has been, I believe, that while we may not be the lowest cost manufacturer, we continue to be the world's leading innovator. And as long as we're the world's leading innovator, IP and the protection thereof is going to be a very important element of our overall competitiveness policy. And we have, the private sector and the government have a variety of tools to address that issue. And one of them is the one that we're going to be discussing today, Section 337. The questions are going to focus on the sort of the larger issues. Is it ready for the changes that have taken place in the trading system? Is it up to date? Is the Commission well equipped to handle what we see as a growth in caseload in this respect? And are there problems that need to be tackled? Are there problems that can be best tackled or have to be tackled legislatively? Or are these problems that can be tackled, within the four corners of the Commission's existing authority? So we'll be exploring those questions. The way we're going to proceed, we have a very distinguished speaker to start with, whom I'll introduce in just a minute. He's going to make a presentation, and then he's going to join the panel. So what we'll do is, once Tom is done talking, I'll ask him and the other panelists to come up, and then we'll have a discussion amongst the panelists on some of these issues. And then if you have questions specifically for Tom, you can ask him then as part of the panel. We won't have a separate Q&A after his remarks. So our speaker is Tom Schaumberg, who is a partner with Aducci, Mastriani, and Schaumberg. He's litigated 337 cases for over 35 years before the U.S. ITC and also the Court of Appeals for the Federal Circuit. He's really, if not the dean, one of the deans of the field in Washington. He's the editor of the first, second, and third editions of the ABA book entitled A Lawyer's Guide to Section 337 Investigations before the U.S. International Trade Commission. And he's currently focusing on issues that have arisen under 337 with respect to non-practicing entities and standard-setting organizations, both terms and some other probably more pejorative terms that you'll hear from time to time during the discussion. So I will introduce the panelists later when we start the panel. So we'll begin right now with Tom, please.
Good morning. Thank you, Bill. Thank you also to the Center for giving us an opportunity to explore Section 337. Bill had originally said I had 10 or 15 minutes to sort of give a little background and history, and I thought, gee, can I go back to 1916 when the Tariff Commission and the statute came into being. I thought, no, I better not do that because that's going to take a little bit longer. So if this works, if I know how to work it, oh, that's too fast. Sorry. All right, here we go. So I decided to divide the talk into three portions, the past, the present, and the future. So I decided that the past really begins with the 1974 Trade Act, and in addition to changing the name of the Tariff Commission to the ITC, probably the most important aspect of that statute was the second bullet, which is that Section 337, which had been more of an advisory function that the Tariff Commission had conducted already for 60 years or so, became a legal subject matter under the Administrative Procedure Act, thereby guaranteeing due process, administrative law judges, and commission review without eliminating the presidential involvement, but that came at the end of the process for policy reasons, and that's still in the statute. Things went along fine, but in the 80s, there was a series of cases that put into question primarily the domestic industry aspect of the statute. As I'm sure most of you know, it is not like a district court patent case where all you have to do is put your patent on the table and you're in business and you have your case started. At the ITC, you also have to have a domestic industry. Why? Because Section 337 is a trade act. Trade acts are in being to protect, using due process, domestic industries that are being affected. It used to be injured, but now we'll just use the word affected by unfair imports. So here we had three cases, the all-terrain wheeled vehicle case and the Gremlins case, where you had two complainants. In the one instance, it was the Shopper Toy Company, and in the Gremlins case, it was, I believe, Warner Brothers. And in neither case could the commission find a domestic industry, because in both of those cases, the effective domestic activity was intellectual property oriented. In other words, the design, the development, the creation of the idea, and ultimately the reality of a new item. And the commission said, we do not have the authority to credit, if that's the right word, licensing as a way of establishing your domestic industry. The other case is also a very interesting one, optical waveguide fibers, a case brought by Dow Corning. They had patents. They won the case. They were able to convince the commission on every issue except injury. And I remember there was a particular gentleman who worked for Dow Corning who felt that it was totally inappropriate for a company that had a legal monopoly by virtue of its patents to be deprived of relief under Section 337. And he and others began to argue that there should not be an injury test in the statute in those cases where, and we'll just use the term, where you have statutory intellectual property, so patents, trademarks, and registered trademarks and copyrights. All of that was brought to the fore in 1988, and as part of a much larger piece of legislation, as far as the Section 337 aspect is concerned, the injury requirement was removed for the statutory intellectual property cases. And so today that is still so. And if you're alleging a general unfair method of competition, common law trademark, trade dress, trade secrets, passing off, all of those kinds of unfair practices, you are still required to demonstrate injury in order to get relief, but not with respect to statutory intellectual property. And perhaps the even more significant aspect of those 88 amendments was the addition of a third, we call it prong, to the domestic industry test, which now enabled engineering, research and development, and licensing to be considered a domestic activity. And that's, of course, a reflection of the fact that an awful lot of production of American ideas and goods was occurring overseas. And in order to capture the value of the intellectual property, Congress said, we need to do more with Section 337 and broaden the test of who and what company would be entitled to utilize the statute. Those words, those concepts have continued to be perhaps the essence of a lot of issues that have come before the Commission in the intervening now 30 years. Shortly, well, actually before the 1988 amendments, the Aramid Fiber case was making its way through the Commission. That was a case brought by DuPont against a Dutch company, AXO, having to do with the manufacture and the process, the method of making Aramid Fiber, which was then being used and still is in military equipment, helmets, vests, and so on. AXO tried to file a counterclaim at the ITC, only to learn that, no, you can have affirmative defenses, but you cannot have counterclaims at the ITC. AXO at the time thought that was pretty unfair because DuPont might well have had good patents to assert against AXO, but AXO also felt it had some pretty good patents to assert against DuPont, and they felt that the playing field was uneven. Those arguments did not avail AXO, and they basically lost. The case was won by DuPont. An exclusion order went into effect, and AXO decided to go to the European community to argue that what the Commission had done and was doing was contrary to the GATT. That process, as you can see, took several years. There was finally a very interesting GATT opinion which explained why Section 337 was discriminatory against foreign parties and therefore had to be remedied in order to be GATT compliant. That took until 1995. The 94 Trade Act finally included the remedial provisions that basically took care of the GATT panel exceptions to the way Section 337 was being conducted. And I don't want to spend too much time here, but one of the complaints AXO had is that not only could it not bring counterclaims, but it was subject to two proceedings at the same time. DuPont had filed not only a 337, but also filed a companion district court case. They said that doesn't happen to American companies. That's discriminatory, therefore, and therefore contrary to the GATT. The removal of counterclaims was dealt with. The time limits, back then, there was a built-in time limit in Section 337. The ordinary case could only take 12 months to make it through, and the so-called more complicated cases could gain an extra 6 months, so 18 months. Again, the argument that the EU made was there's nothing like that in federal court. It's discriminatory. It's obviously designed to put foreign companies that are before the ITC at a disadvantage. And so they said you can't have a time limit in the statute. As a quick aside, most people are not aware of this, but those time limits are actually still in the statute, but limited to temporary exclusion order cases, which are the ITC version of preliminary injunctions. It's an aside because nobody's using it and hasn't used it in quite a number of years. We'll get into that in a moment, but as in district court, you would have to establish irreparable harm, which people have learned is pretty hard to do. And that gets us into the eBay discussion, but we'll save that for another day. Anyway, and then the last point is it defined what was required for a so-called general exclusion order, which is something the Commission had been doing for many years before that, where you might have had a particular respondent, company B, but you had a bunch of other infringers or whatever the action was based on, and the Commission, under the right circumstances, was able to, and continues to be able to, issue an order called a general exclusion order. And I see commissioners in the crowd here who, of course, know all of this, so sorry to repeat some of these things. Nice to see you, Paula, Dean. In any event, the general exclusion order is a way of keeping everything out of the country that would be a violation of the particular finding of the case. The best example, and an early example, was the Rubik's Cube case. Everybody was knocking off Rubik's Cubes. You would have had to name hundreds of companies to get adequate relief. The Commission saw its way clear based on the fact that only a few companies were named, but a sufficient number so that the complainant was able to demonstrate that even relief against the ones that were named would not have been enough because other people would be making Rubik's Cubes and bringing them in. So that's the long story on that. So the Aramid Fiber decision resulted in the last amendments to Section 337. So that was in 1995. This is 2018. So you can do the math. It's been a while before anybody or since anybody found a need to amend the statute. There we go. Okay, the present. I'll go through these quickly. I promised I would say something about eBay. As everyone knows, eBay is the test that's applied in district court in order to get an injunction. One prong of that, well, two of the most important prongs are that you have to prove a likelihood of success on the merits and you have to show irreparable harm. Therefore, it has become more difficult in federal district court to get injunctive relief even after a full trial. Damages are what most people go to district court for. However, the ITC does not award damages. The ITC only has one remedy, essentially, and that's exclusion coupled with cease and desist order. But basically, everybody thinks about 337 as being an exclusionary remedy. And the eBay case has probably driven a few parties to the ITC because they can use the Commission to get the remedy that they would not have been able to get in federal district court. And as I said earlier, the temporary exclusion order, which is the preliminary injunction at the ITC, is still subject to the four-part test as articulated in eBay. And I think somebody in the front row could probably tell me when the last one of those cases made it to the Commission, but it's been a while since anyone has succeeded in bringing a 337 that resulted in a preliminary injunction. The next few cases, Kyocera was an important case. Broadcom, Qualcomm were fighting over the cell phone wars. The question in that case was whether if you went after the chip in the phone, can you also get if you can prove the infringement, can you also get a remedy against the phones themselves, not just the chips? The Commission had historically said yes. The Commission again said yes in the Kyocera case, but the Court of Appeals for the Federal Circuit said no. Reading the statute closely, you have to name whomever you want to go after in a Section 337 case, be it upstream, downstream, or the same stream. You cannot just expect to get relief against unnamed parties other than in the GEO, the General Exclusion Order context that I spoke about before, which is kind of a parallel level. As a result of the court decision, the CAFC, more parties are being named in 337 cases because in order to go downstream to get the components or the end products that are being included in the infringing good, you have to name that party. Very quickly, the Tianray case had to do with the importation of cast steel railway wheels. And the facts of the case were that the misappropriation of trade secrets occurred entirely in China. There was no appropriation or misappropriation in the US. Take the secrets to China and then manufacture the imported infringing article. In that case, the misappropriation actually took place in China. The Commission said that doesn't matter, and the CAFC agreed, and I have to say in a 2-to-1 decision, meaning that the Chinese did get one vote on the question of extraterritorial application of U.S. law. But the holding was that even though the misappropriation took place entirely overseas, there is Section 337 jurisdiction because of the importation of the result of that misappropriation. Suprema, very quickly, there was no infringement at the time of the importation, but there was then a marriage of the hardware with the software, and so there was indirect infringement. The Commission and the Court of Appeals held that indirect infringement at the time of importation does give the Commission subject matter jurisdiction and the ability to impose a remedy. Contrary to the last case, Clear Correct, where the infringement occurred by, has to do with braces, Invisalign, and they would measure the patient in the US, send the measurements, I guess, across the ocean by electronic transmission. The remedial prescription came back in digital form, and then the dentist or whoever it was would put the corrective gizmo in the person's mouth. The Commission, I think, wanted to take jurisdiction, felt that the word article was broad enough to include digital transmissions. I must say there was an awful lot of legislative history that favored that result, but the CAFC said, nope, sorry, the word article, because of something, I've forgotten, 1898 or something, an earlier definition, said no, it does not constitute an article under Section 337 if it's a digital transmission. The future, which is probably most of what we're going to talk about today, but maybe some other subjects as well. NPEs, they were a problem maybe 10, 15 years ago to the Commission because the ITC became the form of choice, I guess, for a lot of NPEs because they could get the respondent, defendant into the ITC quickly and try to cut a quick deal, which they were not able to do in district court. The Commission weighed those cases, began to develop some guidelines, and in my view has done an excellent job of sort of differentiating between the licensor, who is an individual inventor or a university through its hard work has developed new information technology, which is then licensed, versus the aggregator, the non-practicing entity that just accumulates patents in order to assert them. That latter group is not finding much success anymore at the ITC, so that problem has receded. One of the other current issues is standard essential patents and the types of royalties that would be appropriate. The commission, meaning in this case more the administrative law judges, have had some opportunity to deal with SEP and reasonable royalty issues, but it's an ongoing discussion, and I would say there are no clear guidelines yet on where the commission is going. Public interest, in addition to an ultimate presidential review on policy grounds, because it's a trade statute, the statute also contains a public interest test. In other words, is it in the public interest for the goods to be excluded even when there is a violation of the statute? There was a case that between Samsung and Apple where the case worked its way through the commission, through the public interest phase, all the way up to the president, and the U.S. Trade Representative's office submitted a letter basically saying that this would not be the type of case where you would want to have an exclusion order. It didn't appear to them that there had been, in fact, sufficient efforts at negotiating a license between the licensor and the licensee for a standard essential patent. And so they recommended that in the future, the commission look a little bit more carefully at these public interest issues, which the commission has done, I would say, quite ably. And one of the ways it has done that is by assigning the question of public interest fact-finding to the administrative law judge. So the judge is not only deciding the merits of the particular infringement, domestic industry, et cetera, but also making a recommendation to the commission on whether it would be contrary to the public interest for a remedy to issue. Another new idea that the commission took the initiative to institute is the so-called 100-day pilot program, which we're told any day now is going to become a regular part of the commission's rules. But whether it's regular or still a pilot program, it has done its job. It was established to allow for appropriate cases to be terminated early, where it was clear that even though the complainant was able to make out the minimum requirements to have the commission institute the investigation, if you took a little bit deeper dive into the facts of the case, the likelihood would be that there was a problem. And the two problems that have been established in the 6 or 7 cases that have gone so far through the 100-day pilot program to decision is the question of standing. Does the party that brought the case actually have all the rights necessary to the patents, or is there somebody out there that should have been part of the complainant group, much as they would have to be if it were filed in district court as well? And the other one that is being utilized somewhat frequently is there really a domestic industry? People plead domestic industry. They make a pretty good case for it. But again, it's a veneer. If you go a little more deeply into the facts, it turns out, at least in 1 or 2 cases, including the first one that was ever adjudicated under the pilot program, that no, there was not sufficient domestic activity to warrant the use of 337, or certainly not the remedies available. Enforcement, we're going to be talking about that a little bit. Often parties who have lost a case try to figure out a way to continue to bring their product into the United States, as they appropriately can do by, for instance, redesigning a product to avoid the infringing characteristic. But somebody needs to decide, have they in fact succeeded in designing around? That has, let's say, more typically been the role of the Customs Service, followed by the Court of International Trade. I'd say more recently, the ITC has played an ever more important role, because the ITC is, of course, the organization that interpreted, let's say, the patent in the first instance, therefore should have the best handle on whether the redesign was actually effective or just moved the needle a little bit to the right or left and got you into an argument of equivalence or something of that sort. And then finally, the AIA, again, as I'm sure everyone knows, the joinder rules have made it more difficult to bring numerous defendants into one forum, requiring, therefore, multiple lawsuits. The ITC being a jurisdiction where the question of jurisdiction is determined on the basis of the article that is being imported, not the people who are doing it. If you have an article, even if it's being made by many parties overseas, or if it's being imported illegally, as it turns out, by a number of parties in the United States, you can get into the ITC and bring them all into the case, or they risk default. And then the very last point here, IPRs. That has become as you, again, I assume know, a cottage industry at the Patent Office, where patents are being challenged after issuance. And that process can be effective in delaying the progress of a district court patent case. And I would say to date, that has not been so at the Commission. The Commission has been, I would say, quite straightforward on this point in saying that it is not going to concern itself with activities in the Patent Office until there is a final adjudication of the patent, and that usually means that it's gone through the Court of Appeals for the Federal Circuit. So as of now, IPRs are not having any effect. So Bill, thank you. And I just want to say, I know Bill from the days when we tried to fix Section 337 because of the Aramid Fiber decision, and he and his Senator Rockefeller were one of the few offices around town that understood the issue, that cared about the issue, and frankly, that helped tremendously in saving Section 337, because at the time there were people in USTR who were ready to basically trade off Section 337 for other benefits in our trading relationships with various foreign parties, and the Rockefeller team did not think that was a good idea, and that's how we got the statute amended. So thanks, Bill. Thank you.
Done this last week, and I reminded me. Make yourselves comfortable. One of the things that I didn't mention while they're taking their seats, I'll fill in. There is. We are in the Scholl Chair is in the process of writing a report on this subject, a study and review, and possibly including our recommendations. That remains to be seen. It's not finished yet. We wanted to have this event and this discussion first, But once it is done, we will send all of you a link to it. Since assuming you signed up and provided your email address to us, once it's finished, we'll send you a link to it. And of course, then we would welcome any comments that you want to make at that time. But we wanted, as I said, to have this discussion first to help us formulate our conclusions about it. We could have had, I suppose, particularly looking at the audience, a panel composed entirely of former commissioners. But that would probably not have given us the scope that the discussion needs. So we've tried to have a mix of people who all have had a good bit of experience in the field, but come at it from slightly different perspectives, both as commissioner, working on the commission, and practitioners, and in the legislative branch of the government. Let me introduce them all to you. We're not going to have set pieces. I kind of think that's boring. I mean, it might be boring anyway, but I'm going to ask some questions, and I'm going to attempt to see. You're going to have to, turn on your light or shake your, raise your hand or something, because I'm not looking at you, so I can't always tell who wants to talk. But we'll just have a discussion, and then leave plenty of time at the end for all of you to come up with questions if you prefer. Working my way across, the panelists first are Katherine Tye, who is a Democratic Chief Trade Counselor on the House Ways and Means Committee. She's been there from 2014 on, and prior to that served in the Office of the General Counsel at USTR, including service as Chief Counsel for China Trade Enforcement. So she knows a lot about these issues and can, I think, among other things, give us the congressional perspective, which is an important one. Next to her is David Long, who is the founder of Essential Patent Blog and has over 20 years' experience leading complex patent litigation in federal district and appellate courts. He counsels domestic and international clients on IP issues such as patent litigation, licensing, trade secrets, patent re-examination, product clearance and redesign. He's a registered patent attorney before the PTO, where he has litigated post-grant proceedings, often in parallel with related district court legislation. District court, I used the wrong word there, litigation, sorry. Next to David is someone I'm sure is familiar to many of you, which is Deanna Okun, who is a partner with Tom, with Aducci, Mastriani, and Schaumberg, also a former commissioner on the US ITC. During her service there, she served 2 terms as chairman. During the 12 years she was on the commission. Prior to appointment to the ITC, she served as counsel for international affairs to then U.S. Senator Frank Murkowski, who was a member of the Finance Committee in addition to being chairman of the Energy and Natural Resources Committee. And she's also practiced international trade law with a large DC-based law firm, and she was appointed to the Federal Circuit Advisory Council in 2013, and in 2012 was named the Outstanding Woman of the Year by the Association of Women in International Trade. Next to her is Ben Levi, who is a principal with Levi and Snotherly, which is a law firm. He's a trial lawyer and registered patent attorney who has been litigating complex patent disputes at the ITC and in federal district courts for over 20 years. Before forming Levi and Snotherly, Ben specialized in ITC litigation as a partner at a large national law firm for nearly 7 years. And then for 5 years, 2006 to 11, he was senior investigative attorney with the ITC's Office of Unfair Import Investigations. He also served as a patent examiner with PTO in the late 80s and early 90s, where he received the Distinguished Graduate Award from PTO's Patent Academy. So we have a panel here with, and you know Tom, I've introduced him previously. We have a panel here with a wealth of experience and some slightly different perspectives. And I thought there's a number of issues that I want to tease out a little bit about that we can talk about. And I think I was going to start with I think I'll start with a little bit more specific one, which is caseload. Is this growing? Is this an issue? Why is it growing? Do you expect it to continue? And is this a problem? Deanna, do you want to start? Or?
Sure. Well, thank you, and it's a pleasure to be here and a pleasure to be on this panel with the distinguished panelists, and obviously lots of people in the audience who could be up there as well, as Bill observed. So first note that I'm speaking only for myself, not for my clients, and if I slip into speaking about things that happened when I was at the commission, I'm certainly not speaking for the current commission, and current commissioners can certainly weigh in. I see some in the audience. But with respect to caseload, I mean, I think for those who are not as familiar with the ITC, I think there's a little bit of a level set of saying, this isn't district court where there are thousands of cases. This is a very small venue. So when we talk about an increase that happened, in the 2000s, leading up to 2011, of an increase of 20 to 30 cases, we're still talking about a very small increase. And if you look at the value of IP trade and global IP trade that has grown, let's start at 2000 to 2018, it's incredible. And I know, Katherine will know this very well, having been at USTR, but if you look at the level of trade from China of counterfeit and pirated goods into the United States, that's also grown. So I think sometimes my question is, why aren't there more cases at the ITC? Because it is an effective forum for dealing with unfairly traded imports. But if you just want to look at this small time period and say, has there been an increase and what causes it, I'll tick off a couple and others might have a view. There was concern and a lot of rhetoric about non-practicing entities flooding the ITC, and Tom's chart mentioned this, that after the eBay decision. My view of that, and I was at the commission during this time when we were looking at it, was you probably had lawyers on the outside, which I now am, who gave their clients some pretty bad advice and said, hey, you can just go to the ITC and go get your injunction there. And so you had a focus then on what did the domestic industry requirement, which had been changed in '88 to recognize non-practicing entities, how should the commission interpret that? And so there were a series of cases, 2010, 2011, where the commission, I think, effectively, I don't know if the right word is to say raised the threshold, but took a look at the statute and gave, I think, clear indications to potential complainants at the ITC that you had to have a domestic industry under, whether it was under prong A, B, or C, and that you were going to have to put forward a lot of information to establish that. And so I think that to the extent there were patent assertion entities of the litigation type, the ITC calls them type 2, category 2, I guess, there were very few. I mean, we're talking about 2 or 3, 1 or 2, 3, and there were some cases where complainants were not successful in establishing a domestic industry. So I think the commission did deal with things. I don't think it was as an onslaught, but that is part of what I think we saw in the 2009 to 2013. And then there's a little bit of an increase now, and others might want to comment on what they see currently.
Anybody else want to comment?
Yeah, I'll step in. I agree with everything that Deanna said. And part of it, too, is when you look in the early 2000 timeframe, not only were we seeing more products made abroad and then therefore being imported, some of you may be familiar with the Rocket Docket in the Eastern District of Virginia. And that used to be the place to go because you'd get very quick resolution of your patent infringement case, where the Eastern District of Virginia, around the 2000 timeframe, decided we're tired of doing all these patent cases. They're no longer Rocket Docket. So one thing you saw was, well, where's another Rocket Docket, in other words, fast adjudication place? And that was the ITC. In 2006, of course, you had the eBay decision, which raised a lot of questions whether or not you could get exclusionary relief. And keep in mind, with patents, the entire patent right is premised on the right to exclude. And so there's a huge question about, after all the trial and everything you did, could you get and enforce that right to exclude? Meanwhile, at the ITC, you had a lot more predictability. The relief is going to be an exclusion order. So there's just a lot more predictability in what would happen if you managed to establish your case. So I think that's a big part of it. We see venue issues. If there's multiple defendants that you need to, that are infringing your patent, you can go to the ITC and have venue over, as Tom mentioned, the product, not worry about which court you can sue some defendants in and not others.
Just two other points on that, just again, I think it picks up on what David said, which is if you are a company that's facing, you have a product that has a fairly short life cycle, right? I mean, there is, while the Commission doesn't have statutory timetables, it does try to move very efficiently. It's taken steps to continue to move these cases, fairly efficiently and within 18 months usually. So for a lot of companies, that's important, that you don't want to be in district court for 3 or 4 years, and I think that relates to the Rocket Docket that you have predictability often in the time frame.
One of the comments that, one of the issues that has been alluded to, it was a feature of Tom's comments, was the single remedy, or the effectively single remedy of the exclusion order, which I guess from my perspective is kind of a nuclear option, and one in which the Commission does not have a lot of choices. I wonder if we can spend a few minutes just talking about the effect that has both on the process and on the Commission's consideration, and then subsequently how bringing in the public interest issues affects the decision-making process. I guess I'm going to ask a couple questions, and you guys can pick out the ones that you want to respond to. Because it is such a nuclear option, particularly if you're talking about consumer items where there's a big market and there would be a big impact on an exclusion order, does that, on the one hand, increase the number of cases that are brought to the Commission? Does it, on the other hand, does it make the Commission think twice about imposing the remedy if there would be a large consumer impact? Can the Commission, or does the Commission, tailor exclusion orders and cease and desist orders to tackle complex products, and similar to an injunction, just dictate that the infringing aspect be excluded rather than the entire product? Anybody want to comment on any of those issues, how this plays out in the process?
I'm just going to mention one thing. I want to rephrase your question because you called it a nuclear option. I would call it more a traditional option because the right to exclude is the essence of the patent right. And so that had been traditionally what you obtained in district courts for decades. eBay changed that a little bit. That's my comment. I may have more, but just rephrase the question.
Okay.
Yeah, it is true that since the eBay decision, unlike in a district court, exclusionary remedies in the ITC are automatic, barring any public interest concerns. Respondents have, since then, they've attempted to use the public interest factors to try to urge the Commission to tailor certain remedies. So you termed it a nuclear option. I think the Commission has discretion in fashioning remedies, and they don't have to use a machete in every case. They can take out the scalpel if the facts in any particular case warrant to, for example, delay implementation of a remedy or carve out products that have been adjudicated as non-infringing from the remedy. So they have some, they have tools in their tool shed to fashion the remedy that's appropriate in the particular investigation.
If I could just add to that, the very fact that, as Bill characterizes it, it's a nuclear option means that the defendant, respondent in the case, has some very important decisions to make, because if that is the key product that is being imported, it's a major product in the product line, there has to be a decision, do I want to go all the way, either to find out that I don't win the case or that I don't win the public interest argument thereafter. And as a result of that dynamic, there used to be an approximate 50% settlement rate at the ITC. I think it's actually gone up because bigger cases, bigger value, less willingness to take risks. So what begins as a case for exclusion often ends up as either a national or a global settlement between the complainant and the respondent, which could result in a license. It could result in an approval of a design around. There are many different ways, as there are many different approaches to working things out. And so the commission, for that reason, is also a good place to bring your case, because you get to the point of where you have to make that choice, both as a complainant and as a respondent, that you're better off settling than taking the case all the way. And having said that, I can tell you there have been cases that have gone all the way through hearing, and just before the administrative law judge is ready to issue his or her initial determination, the parties say, okay, I think we better settle because we don't know how this is going to work out. So that's an important aspect of 337 practice.
We might want to go to a different question, but just a couple of things. I mean, that I find important, which is, it was my experience at the commission, and if I sound like a cheerleader for the commission, I am a big defender of the institution, but one of the things that I think is great is that it's technology neutral, it's business model neutral, right? The commission is taking the facts. So you mentioned consumer goods, and for me, I just think, you as a complainant come in with whatever your IPR is, or whether you're talking about unfair act like trade secrets or anything else, and you come to the commission, and if the commission agrees that it's been violated, then exclusion order is the appropriate remedy. But then there are these public interest factors, which include impact on consumers, that the commission can take into effect, and has indeed taken those into effect to remedy, as Ben points out. So I think that's, I don't see it as a commission saying, oh, we can't do an exclusion order because it's a consumer good. It's, you're looking at was there a violation, and once you've found that, then the commission goes through the analysis of the impact on the public interest factors, where they can tailor the remedy. And at the end of the day, as Tom pointed out, this is a trade statute, and the president has all the policy reasons if he wants to, through the USTR, to say there shouldn't be an order. So there's a lot of protections built in.
Going a step further on the public interest issue, and correct me if I'm getting this wrong, as I understand it, what the commission determines is whether it would be against the public interest to exclude the infringing product. Would it make any difference, or what would happen if that were flipped around and the commission had to determine that it was in the public interest to exclude the product? Be brave, somebody.
Okay, I'll take the bait. Just one observation is that the public interest inquiry actually technically has no burden of proof on either side. It's more of a practical issue that if you want to show the public interest is against bringing the product in, you need to tell the ITC why. So actually there is no real burden of proof other than burden of production, because the ITC can't consider arguments and evidence that it hasn't heard.
Yeah. Deanna?
Yeah, well, and again, I mean, I think it's the bad analogy, but the cart before the horse. I mean, you're right that I think the statute has the setup exactly right, which is you go through and determine whether there's been a violation, and then you determine whether there would be an impact, adverse impact on the 4 statutory factors that Congress told the commission to consider. And so again, if you flip that around, yeah, would it change it? I think it would change. I think it would change it dramatically, because you don't even know. I mean, when a complainant brings a case, let's say they bring a case, and let's use patents, even though there are other things you could do. You might start out with 6 patents, and by the time you get down to it, at the end of the case, you're down to 3 patents. So you're not even like you would assume everything's going to be excluded, and so. I think it's the wrong analysis. I think it shifts away from the importance of protecting intellectual property rights and unfair acts from abroad to something much different, and something the commission. I don't think that's what Congress had in mind. So I wouldn't want the commission to do that. I think it should be doing that on its own at this point. Okay.
Tom?
Yeah, and both the commission and the courts have said that the underlying public interest is in the protection of valid intellectual property. So you have to overcome, as a respondent, that underlying public interest before you get to the point of succeeding in showing that it is against the public interest for the commission to impose the remedy. So I'd say it's a pretty high standard to get to that point.
Yeah, I would agree. Deanna mentioned the statute. The way the statute is worded, Congress directed the ITC that the remedy shall issue, they use that word shall, unless there are public interest concerns. And I think Tom is certainly correct that it is the infrequent case where there are public interest concerns that prevent the issuance of a remedy. And then there are some cases where I mentioned earlier where there are some public interest concerns that merit a tweaking or tailoring of the remedy in the public interest.
And one thing that, Bill, we could pick up on there, which Tom mentioned in his chart, which is the commission, we can go back, the Broadcom versus Qualcomm case was mentioned, and that was one with the downstream handsets, and the commission had a public hearing and went through and issued a tailored remedy at that point. But one of the things we learned in talking to USTR after that, and was a conversation that was going on, which was it would probably help to have more, the record developed more fully. And so one of the things the commission did on its own initiative was say, in cases where we think, based on the complaint, which is a pretty thorough complaint, we think there are potential public interest concerns that should be raised, we're going to delegate that to the judge. And so the latest statistics that I had, that since the Commission started delegating public interest to the ALJ, to ALJs in 2011, there have been over 80 cases that have been delegated. Now, only 15 have gone far enough for the ALJ to hold a trial, which is somewhat consistent with settlement and everything else going on. And of those cases, there have been some where the judge has recommended issuing a tailored remedy as well. So I think that program, while the commission, as part of its rulemaking, may want to think about whether it's adding to the costs of litigation, because there's a lot of attention now paid to it, I do think it helps develop the record. And because in those cases, the Office of Unfair Import Investigations is in those instances always assigned, or almost, Margaret will correct me, but I would say almost always assigned to be part of that case, they are there as well to make sure that the record is fully developed. So while the ALJ issues a recommended determination, it's still the commissions will still see a fully developed record that the ALJ and OUII have helped put before the commission. So I think that that, to me, gets to this issue of, are they considering this before an exclusion order is
I would
implemented?
just add a small point that in this process that Deanna alluded to, the commission invites members of the public, not just the parties, the complainant and the respondent, but they'll seek comments from anybody. If they're aware of any public interest concerns, bring those to the commission's attention at the outset. And they'll take it into consideration in determining whether that particular investigation merits additional fact-finding before the ALJ.
I think some important cases have been mentioned both by Tom and in your comments, and one of my observations has been, I think, that as this is an issue that kind of bumped along for a long time with people that were paying the closest attention were the people that were involved in the cases, and it's of interest to the legal community and the affected parties. As the statute has become more frequently used, there have been also a number of cases that are big, that involve, where the stakes are much higher, that involve a lot more money in terms of the rights that are at stake, and also because sometimes they involve consumer items, they involve lots and lots of sales and would affect lots and lots of people depending upon how they come out. That, I think, implies that there's a lot more, and will probably be in the future, a lot more interest in how these things progress and as they're going along, which in turn raises the question of politicization, which I think historically has not really been a problem at the Commission on these cases. By politicization, I guess I would mean more than the usual on-the-record lobbying efforts trying to influence either the ALJs or the commissioners. So the question is, and maybe I'll start with Katherine on this and then move on to the others, are we seeing increased interest in the progress of these cases and the outcome of these cases, first from members of Congress or congressional committees, and also from other stakeholders. And if we are seeing greater interest, is that interest coming in earlier in the process, and are we seeing more attempts to influence the process, or is it continuing to proceed as it always has?
Thanks, Bill. Since I know that this is being live streamed, it seems like it's a little silly to think about this as being off the record, but I just want to emphasize I'm here in my personal capacity and, admittedly, am not a 337 expert, but given the congressional role, I will do my best to do what we do best, which is to react to the education that we receive from everyone else around. In terms of the politicization, I would say that Section 337 popping up on the radar of congressional staffs reminds me of when other types of proceedings pop up on our radar, whether they are trade remedies proceedings. In the past year, the 201 proceedings, which are also ITC-focused process. Traditionally, I think that when they come up on the radar, it's because there is often a district-based interest that is having its profile raised with a member of Congress. Generally, our advice to our offices is, well, there's a very robust process that's not political in nature, mostly. When you, as a member of Congress, weigh in, please, give some thought to and recognize the integrity of that process, and also be sensitive to where there are intervening points built into the process where political interests or public interests are supposed to be taken into account. I was thinking in preparation for this panel for the times in the recent past where 337 issues have really come up on our radar outside of that usual context. And I would say that the U.S. Steel case was something that got a lot of attention on the Hill, partly because I think that in a number of ways it was pushing the envelope on the 337 as a tool and as an enforcement mechanism, and partly because it is the U.S. steel industry, and partly because it is the U.S. steel industry versus China Inc. So that's one area. I would share one other data point. Recently, 337 has come back up on our radar. We now have a member of our team who we have recruited from USTR's IP office, and we're very excited about it to have the IP expertise on our staff. But we recently had started an exercise looking at IP rights enforcement in the current age of digital trade and e-commerce. And one of the issues that's come up for us is for a lot of these market participants and intellectual property rights holders who are small businesses or even individuals in this new environment. What are their realistic options for getting relief and enforcing their rights? And it's quite challenging. And one of the tools that we put out there to look for fit was 337. And one of the dynamics that became apparent to us is 337, I think, is fair to say, a very effective tool. I think that these enforcement tools often become it's like what they have said about becoming a partner at a law firm, that it's the reward for a pie eating contest is more pie. That the reward for an enforcement tool's success is a lot more enforcement activity. But I think a question that we are interested in examining sort of more broadly is whether or not Section 337 can be something that works for smaller businesses and entities, and if not, are there effective tools out there? And if not, then should we be looking at crafting or making available tools?
Anybody else want to comment?
Sure. Well, I think that initiative sounds fantastic, and I think that's great, and I hope that you're talking to ITC and USTR and others about that, because I do think that's one thing that has concerned us is, the cases can be expensive. We can talk about how that is relative to district court, but for smaller companies, are there some alternatives? And Tom might have some ideas, but I did want to just make a point on the politicization again, just speaking from my own experience. But I think when Congress set up the ITC, as opposed to some of the other agencies like the FTC or the FCC, Congress was very, I think, took a lot of steps to remove the politicization at a high level. So for those of you who know, I mean, the 6 commissioners, it's an odd number, no more than 3 from any party. The chairmanship, instead of the president getting to appoint a chairman when he becomes president and having an extra vote on a body like the FCC or the FTC that has substantive rulemaking authority, the chairmanship of the ITC rotates twice a year. Like I used to say, oh, it's so great. People say, oh, you were chairman of the ITC. I'm like, yeah, until you know that you have almost no power, and the power is sitting at this row right here of the career staff at the ITC who do such a terrific job. But that removes the commission. So while you could have ex-party contacts, I guess, at least when I was on the commission, commissioners did not meet with individual parties, because if you meet with someone, if I met with someone who had a case before me, I'd have to, put a memo out saying I met with this person and here's what we discussed. And so it has been the tradition of the ITC to not do that, which I do think removes a lot of the politicization, even though they're political appointees that go up there. And I think. So I think that's been helpful, Bill, in terms of that the institution is set up so that it's not as politicized as some other agencies, and therefore it's continuity both in case law and, well, I guess I would stop there.
And the transparency element you mentioned, I think, is important too.
Yeah.
Tom, and then Ben.
Yeah. I was just going to say, not so much on the political question, but on the small business question. I recently got a call from someone who had an interest in a product that person would have liked to have taken to the ITC, but it was a very, very small operation. And so I recommended to this person that he go to the Office of Unfair Import Investigations, who would help put the complaint together and put him in a position at least to file the complaint. He called me again and said, well, I've talked to them and they were very helpful, but I also know that if I file this complaint, I'm likely to run into some opponents who are going to cost me a lot of money. And so I went to Deanna and I said, what do I tell this person? And Deanna said, well, there is a trade remedy office at the U.S. International Trade Commission where a small business person could go. So I called the person back and said, there's a small business trade remedy office at the ITC that you could go. He said, well, in the meantime, I've gotten together with some other people who are also unhappy about the fact that the type of knockoff that I'm complaining about is also the type that lots of other people are complaining about, and they're all coming in through various large internet-based organizations who will remain nameless, and we have decided that we're going to try to talk to them directly. And I said, well, that's a great idea, and that was kind of the end of the conversation. But the point is, I think if it were better understood and better known that small business people can get help from the ITC directly, both in terms of preparing complaints, but also pursuing them thereafter, I think that would be a tremendous service.
Yeah, a couple of points. On the question of small business owners and small entities that are IP rights holders, I think that, from my perspective, I think the Commission has been particularly sensitive in their rulings on that question. So I think there is a desire, from what I've seen, from my perspective, that the Commission wants the ITC in Section 337 to be available for everybody, not just the larger entities. On the question of politicization, my perspective on that is not so much politics impacting at the commission level. Rather, I see it in terms of the commission as an institution responding to concerns from Capitol Hill and perhaps responding to lobbying efforts by companies. And we've heard some discussion about some steps the commission has taken. I think those steps were taken in response to concerns voiced by others. We discussed the public interest, examining the public interest at the outset of a case. There's the 100-day program, which the commission instituted recently. There's also been a heightening of the bar on domestic industry. I think it's an open question as to whether perhaps that needs to be recorrected or swung back a little. But certainly the commission has, as an institution, taken steps on its own to, from my perspective, again, they've taken these steps to tell Congress, leave 337 alone. You don't need to amend anything. We can, to the extent there are concerns, to the extent you're voicing concerns, we can address it on our own.
It's good to hear, I think, about the efforts underway to help SME, small, medium-sized, I guess, enterprises obtain relief. This is a chronic problem. Maybe as long ago as when I worked on the Hill, it was something that people were always discussing, even in other aspects of trade remedy law. For bringing an anti-dumping countervailing duty case, for example, is also complicated and probably more important, expensive. And for small companies, that's a burden. And Congress has wrestled with this for probably 40 years, not entirely successfully, but it's good. It's good to hear that there are at least some efforts underway right now to deal with it. This is perhaps a kind of an unfair question for Katherine, but I'm going to ask her anyway. Does Congress provide sufficient oversight over 337?
Let me answer that question a couple ways. Does Congress provide oversight? Yes. Is it sufficient? I guess that's really in the eye of the beholder, and that's probably a question for my fellow panelists.
I'm going to ask the rest of them.
Yes. I would be very interested to hear.
Anybody want to comment on the sufficiency of congressional oversight? Anybody brave? Deanna?
Well, I mean, I'll just give my perspective, which is because the commission is responsible for its own budget and going up to the Hill to get a budget, unlike other agencies, the commission actually is meeting with the authorizing committees and the appropriators, and that was my experience there, that you are hearing from them if they've had concerns or if they've had people come in. And so part of that is obviously a resource question. So one of the things that I think the commission has done, which was in 337, they sought additional funding for another courtroom to handle the cases, to keep them moving along. They added lawyers with technical backgrounds to aid commissioners in decision-making from the offices. And the OUII office is filled with experts. So I think that those are the types of conversations that they have when they go to the Hill, and so in that way I think there is a lot of it's not being filtered through an administration. It's very direct of you, the commission, what are you doing with this money? And also because the commission in the other part of its mission does studies for, on behalf of the USTR and Senate Finance Committee, or at a request from USTR, there were studies on SMEs, for example. I think that's another avenue where the commission understands kind of where there are issues, what they should be looking at, not just in 337, but kind of across there. So that would be one way where I think there is that type of oversight. They don't get the money if they, right? There are purse strings.
Well, I think actually both these comments have been enlightening. First of all, it's clear, there's more ways to perform oversight than have a public hearing. There's dialogue, there's review, there's correspondence. There's meetings and all of the things that you've described as a way for Congress to reflect its concern. At the same time, I think it's probably, just to editorialize for a moment, it's probably good practice periodically, and I don't know how often periodically is, for one or both of the relevant committees simply to have a hearing on the operation of the statute, and whether there are, people that are unhappy. Maybe they're just unhappy because they lost, but people who are unhappy can come in and explain why they're unhappy, and Congress can address that, or can think about whether it wants to address those issues. But let's use that as a segue into the next question. And we've kind of danced around this a little bit, and I want to try to see what, push you a little bit on it. One of the questions I was going to begin with, or the question I was going to begin with was, well, if it ain't broke, do we need to fix it? Do we need to fix it? And I thought we'd start with some more specifics, probably then get into that question. But there are, I think, pending a small number of proposals, legislative proposals to fix it. And there's, I'm sure, no shortage of people out there in the wilderness, maybe some of you in the audience, who would say, well, if the commission would just do things this way and change its procedures, that would be better. And we probably should spend a few minutes talking about any of that. Do you have information on on pending legislation? Is there anything going on the Hill on this, or is it more or less dormant?
So I did a search last night in preparation when I saw this question. There are one or two bills that have been proposed this Congress. That's all that I'm aware of. And so if there's more out there in the sort of the pre-introduction phase, I'd be very interested to hear about them.
Well, I have no beans to spill with respect to pre-introduction, but anybody else want to comment on, anybody familiar with any of the pending bills that are out there? There's one I'm going to ask you about.
The Farron-Cardenas bill that probably Katherine is aware of was
Which would do
introduced.
what? Can we, roughly?
Okay, well, I didn't bring it, but it had several provisions. One, it would make, would make the 100-day program permanent, but the commission is already in the process of rulemaking, and that's probably going to be done, so I think that one's going to be off there. It does have a public interest provision where it would do more of this cart before the horse kind of thing, put public interest before, and then also broaden from the four factors into, I think the language is other considerations. And if you look at some of the testimony that House Judiciary had on the ITC in prior years, there's this view that the commission should be looking at all kinds of other things. So I guess that would go to that part. With respect to domestic industry, I'm trying to remember the specific provision, because I'm forgetting. I think it's unnecessary, so I'm forgetting what it is. but so it was domestic industry, 100-day, and public interest, and I think those were the three high points in it.
This is sort of an historical take. Years ago, and one of the ladies in the front row might remember the date, there was a decision in the Court of Appeals for the Federal Circuit that was called Vast Fame. And Vast Fame stood for the proposition that if you were the subject of a general exclusion order, I mentioned earlier how you could be subject to such an order even if you had never participated in the case. Even if you knew about the case, you could be subject to the general exclusion order. And Vast Fame stood for the proposition that even if you had not participated in the case, even if you had known about the case, if your product is subsequently stopped at the border, you would have the right to defend your position, i.e., to try to prove the invalidity of the patent that was the subject matter of this long hearing that had already taken place before the commission. And I remember 15, 20 years ago, whenever that was, feeling very upset about that and thinking, somebody should go to Congress, somebody ought to fix that. I am not aware of anybody who has spoken about that issue. I'm not aware, since that date, I'm not aware of anybody who has, in fact, been the subject of a general exclusion order that subsequently attacked the underlying patent. So whether we all feel good or not, the Commission has not only been very good at dealing with many of the issues that have arisen, time also seems to make some problems go away. And the risk with legislation, as you, Bill, and Katherine know best of all, it's an opportunity for people to attach, call it non-germane, particularly relevant issues onto the legislation that was originally designed to deal with a particular problem, but then ends up opening a whole can of worms.
Yeah, David?
Yeah, I want to touch on one of the cases Tom mentioned earlier as well, the clear correct decision. Right, so what's defined and what can be stopped at the border is based on a 1920 dictionary definition of article. And there's probably not much that can be done about that now, absent legislation. But in today's digital age, I mean, I have a master's in EE, worked in industry. The whole goal was to take everything out of the real world, or the analog world, as us engineers call it, and put it in the digital realm because there's so much you can do. Look at it in the Clear Connect case. They took moldings, sent them overseas. Overseas, they made digital models of the things you would put in your teeth, but they didn't need to manufacture them and send them. They just sent the plans for it, the model for it to the U.S., and then that could be printed out readily in the U.S. Plainly, there's something unfair and a trade problem with that, but using a 1920 dictionary definition of article is just as what ain't right, as we'd say back home. And so I think there should be some cure for that, being very mindful of Tom's wise advice that mischief can be done once Congress starts tinkering.
And can I add one thing on that, Bill? Just,
Yeah.
well, one point which obviously Katherine is looking at this, which is, we are in this world of increasing digitalization and cross-border data flows. But with respect to clear correct and 3D printing, I think for any manufacturer out there, a manufacturer, they have to be thinking about that. I mean, can these border laws be avoided just by sending over our data and then printing it out here and then selling it, having unfairly appropriated someone's intellectual property? So I think there's an issue there. But I do think that it's possible that can be addressed through a future case, because the facts of clear correct, while I think the CAFC got it wrong because of their use of this old definition when there was a lot of other information out there that I think supported a different reading of the statute, I do think that the facts were such that a different case could come up in light of Suprema, where the Commission could come to a different result, and perhaps a different federal circuit, different set of federal circuit judges could come to a different decision. So I leave it that there might be a case. So if you want to bring it, come talk to me.
This gives me an opportunity to do a short commercial, which is to refer you to the paper that Scott Miller produced and that we both did an event on a couple of weeks ago on additive manufacturing, which is the new term for 3D printing. And if you want to catch Scott afterwards, he can tell you about how they are now printing houses using 3D printers, which I think is fascinating. But it raises a whole new set of issues because the fact situation is exactly what David described. The imprint of the patient's mouth was taken here. It was shipped overseas. It was put into code there, which is in turn digitized there, which is in turn shipped here, and the product was printed in the United States. So the product, the article, was not imported. It was manufactured domestically. What was imported was basically the source code that permitted the printing of the product. That opens up a whole new avenue of activities in many ways, not only for 337, but in terms of what it's going to do to the economy generally and assembly lines and a host of other things. So if you want to know about that, go to our website and get the additive manufacturing report, and you'll get a good tutorial in that. On this issue, I think I infer from what Katherine said and from the rest of you said that while things are pending, it doesn't sound like anything is moving very fast, or if at all. And there is always in Congress, and particularly on trade, as we see all the time, the concern that Tom expressed, which is when the train starts to leave the station, there's a lot of people that want to climb aboard. and they may not be passengers that you want. And the result is that trade bills tend to occur infrequently, and they tend to be closely managed in order to make sure that they stay germane to their original content. That's easier in the House because the House has rules. I spent most of my time in the Senate, which has lots of rules, but they really amount to no rules, and where things are always opportunities for amendment. But it doesn't sound like anything is hot at this particular point. We're getting close to the time for the audience. I do want to wrap up with a couple more questions. One is to ask some of you, or any of you that want to comment on the enforcement question. The Commission makes a decision, it issues an exclusion order. Let's assume that's not appealed, it just goes into effect. Do products get in anyway? Is enforcement a problem? How hard, somebody, Tom, I think, commented on this, but maybe the rest of you can say a few words too, or some of you. Is it hard for CBP to identify and block them? Are there resource issues there that you know about? Is this something, Tom alluded to the Commission's having a role in some aspects of this. Does anybody want to elaborate on what Tom said or disagree with him? Ben?
Yeah, Customs, so as I think everybody knows, Customs is responsible for enforcing the exclusion order that the Commission issues. Enforcement of cease and desist orders are something that are handled separately by the Commission itself. But as to Customs, they've recently instituted informal inter partes procedures to take evidence from both sides when there's a dispute as to whether a given good falls within or without the scope of an exclusion order. I was just involved in one of these procedures, and I can say that Customs takes their role extremely seriously. They had a hearing. They take briefs, written submissions from the parties. They'll examine the physical article if they want to. There were 5 attorneys, I think, who were involved in the decision making. So from that perspective, I think I don't speak for Customs, but from my perspective, they take it very seriously. I'll just add in terms of enforcement, the Commission also has a role in enforcement procedures. A party can file a complaint seeking to enforce at the Commission level an exclusion order, and I think those are the high points.
Can I just add a couple of things, Bill? Because I've also been involved in these procedures. So for those of you who have been following this for a long time, under the Obama administration, there was this effort for the IPEC to look at enforcement of Section 337, and there were submissions by law firms and companies, and everyone identified that there were problems with the enforcement and with the kind of what was happening. And one of the big concerns on the Customs side was that it was ex parte, so the rights owner had no idea what the respondent was down there telling them. So there were a lot of people saying, hey, this would be better if it were inter partes. They've been trying to do rulemaking for years. It's never happened. It's still not happening. But they decided to go forward and adopt these inter partes procedures, somewhat like a pilot program, I guess, like the ITC does. And so they have them. Having gone through them, I think they have some of the same problems that people identified before, and not because CBP doesn't have doesn't care and isn't trying to, and has skilled people, but they didn't just go through 18 months of going through the litigation and the evidence and the record. And so you go down there for this hearing, and they also don't follow the APA, right? So like ours, there's discovery. You got someone who's never been a judge sitting there telling you, how are you going to resolve a discovery dispute? How are you going to does this expert get to come in? Do you get to question him? I mean, so as much as I think that a lot of us asked for, let's go inter partes itself has its own problems because there are no guardrails on it right now. And so they've got to do some rulemaking to make that work, in my mind. I think I pick up what Ben said, though. I think the commission, they did make some changes in terms of the timetable for these enforcement proceedings or advisory opinions or modification proceedings. And I think that is a way to encourage parties to go back to the ITC to enforce. And we should also add, I know we give this advice, which is if you're a respondent, and again, you have the patent right gives you the monopoly, but you can design around. Put your design around in front of the ALJ, and if it gets blessed, you have no issues. And so, not everyone wants to do that, and there are reasons not to. But I think there continues to be a problem with enforcement. I think the commission clearly has a role. It's better positioned, having gone through the cases, but they don't have the resources to enforce at the border. But I think that just going to this inter-parties light, as I'll call it, is not going to resolve a lot of the issues that have been identified by both rights holders and respondents.
There are clearly parallel avenues where the exclusion order is enforced at customs and then through the ITC. I think there is some merit to the view that you just expressed, that the commission's familiar with the record and they may be better positioned. And I believe at one point, customs several years ago in a letter to Congressman, I don't recall his name, pretty much conceded that. But the problem is they don't have the choice. An importer can choose to go, or a complainant can choose to go to one side or the other. So I think both the commission and customs have to be prepared to deal with the issues. And I think from what I've seen, customs, as well as recently the commission, where they've instituted some streamlined procedures to handle enforcement. I think both institutions are doing pretty good jobs at this point.
Okay, let's then, I was going to ask a question about non-practicing entities, but I think Tom covered that pretty effectively in his remarks, and so we may get into that via the audience, but I'm aware of the passage of time, so let me just ask one final question to put you on the spot. And Katherine, you can punt, but I hope if you want, but I mean, you don't have to, but you can. The rest of you, can you, each of you give me one or more, but at least one recommendation of changes in law or commission practice that you'd recommend. I'll start with Tom and work our way this way.
I'm not sure that there's anything specific to change. I have noticed that the public interest issue is getting a little bit out of hand in terms of what it is costing the parties in the case. USTR expressed its views in the Apple-Samsung case that the commission needed to create a more complete record. The commission has done, and the judges have done what USTR asked to be done, but I think an awful lot of wind is being blown on the public interest issue in cases where that's a very hard point to be made. There are cases that deserve more analysis, and we're getting that, but I think it's being overdone.
Ben?
I have two, but if you're limiting me to one.
No, you can have two. It's all right.
So I mentioned earlier in one of my comments, and I think others have mentioned it also, that the commission has taken steps recently to raise the bar on domestic industry. One issue that I think all of us, policymakers, those at the commission, should consider is, has the commission gone too far in the nexus requirement in proving domestic industry based on research and development under prong C of the statute? Just as a policy matter, do we want to discourage research and development in this country? Do we want to discourage protection of research and development industries in this country? So it's, as a practical matter, it's difficult, some might say unworkable, to have this nexus requirement. So that's something I think that merits further or close attention, and that would be what I would throw up there.
Okay, Deanna?
So if we were voting, I'd vote with Ben on that. I do think that's an area where I think the commission could take another look at how these cases have been decided, because I think one of the outcomes of the problem that Ben identified in kind of this very strict interpretation, or I don't know if strict interpretation, the interpretation that the commission is giving it is that you do see companies who might have licensing R&D and might be able to, should be maybe considered a prong C domestic industry, turning to their licensees and having to subpoena their licensees in order to take the easy way out, because the commission has blessed that you can rely on your licensee. And so I know that's another area, and I don't know if Catherine's had folks talk to her about that, but I know that is an area where people have been concerned. And again, not speaking for any client because we've relied on licensees, but because the commissions have blessed it, I do think there is a policy issue there. Most licensees, you would think, should have an interest, but they don't always. Sometimes they've taken a portfolio licensing or portfolio, and they don't really care about the particular issue or patents at issue. So I would think that's someplace where the commission could address that and make it clear that when Congress amended the statute, added prong C, included licensing, R&D, and engineering, that this nexus requirement should be read in light of that statutory guidance and history. And then my second quick one, unrelated to anything we've talked about, but while I was there, I would say I think that the Sunshine Act should be amended for the ITC so that the commissioners could act as they do in deciding these cases in a quasi-judicial sense and talk to each other. For anyone who's not familiar with it, the commission under the Sunshine Act can't talk to more than a quorum. So if there's 6 people, you can't have 2 other commissioners and talk about a case that you're going to decide. Your aides can do so. The commission makes it work, has for many years. But I really think that it would be better decision making if commissioners could talk on cases.
David?
Okay, first, I already actually satisfied your question with the article, definition of article,
yes,
but
you did.
I'll throw in a bonus, a little bit more obscure one, perhaps, but it's for the cease and desist order needing to show that the respondent has substantial inventory of product in the U.S. That seems like a waste of time to me in a sense. If they have no inventory, they may not care about a cease and desist order. If they have a lot of inventory, you do. So I think that's something that the commission might want to look more at. And then finally, I'll say I looked at a lot of statistics on NPEs in preparation for today's discussion, so I got $1 for anyone that'll ask me a question about it.
Do you want to punt or do you want to say something?
I was going to try to collect on that $1, but otherwise.
All right, let's go to all of you. If you have a question, please, the rules are raise your hand, wait for the microphone. We do have a microphone? Good. Tell us who you are, and please ask a question, not a speech. Paula, we know who you are, but identify yourself anyway.
Hi, I'm Paula Stern, and I had the great pleasure and privilege of chairing the U.S. International Trade Commission, where I sat for 10 years. And I do feel a great deal of nostalgia and also appreciation, as Deanna has so articulately stated, for how the ITC operates. My question is, I'll pose it in this way. 2 words I don't think I heard this morning. President, presidential review in particular, and the Constitution. Tom answered one of the questions that Bill asked with regard to public interest and what is the presumption of the public, which I always kind of wrap in the word Constitution. So I was just curious about this, and I'm really interested in the presidential review aspects here, given what we did see so surprisingly when the President Obama, in effect, overturned an ITC decision after all the public interest was taken into account.
Anybody want to comment?
Well, let me
Deanna?
just start, and then just 2 things. First, on the constitutional thing, because I think it's such an interesting point. I mean, again, patent rights protected in our Constitution, and that goes back, I think, to what David said, which is this is a fundamental, a property right, and should be protected, and we should take it from there. And I remember when I was at the commission, and these were, early 2000s when we were going to visit China, and they would say, like, when you're talking about intellectual property, remember, the United States enshrines it, the founding fathers enshrined it. China doesn't quite see it that way, and you need to think about it. So it is a really important point that you bring up, that this is grounded in the Constitution and in the protection of property rights, and I think that's how it should be viewed. And then with respect to presidential review, we could talk about the Samsung Apple case as an outlier in that it related very specifically to what the Department of Justice and FTC had to say about standard essential patents, and that was part of it. And in fact, the next case that went up, the Obama administration approved. But I can say I disagreed with that decision, but it is the president's decision to make. My experience, on the outside now and being part of that USTR process is they do take it seriously. They, I think, are trying to have practices that are not quite transparent the way the ITC is, but that they are, inviting parties. If you want to come in, that they tell the other side that they're talking to you, and if you want to have a meeting with X, you get a meeting with X as well. So again, I guess I think that is working. So I'll leave it there. I don't know if there's.
Yeah, I certainly agree with everything Deanna says about intellectual property rights with respect to Article 1, Section 8, Clause 8. The only observation I would add to that is Section 337 is a trade statute, and the judges are not Article 3 judges. They're, as I'm sure everybody here knows, are Article 2 judges. So, that's just another gloss that I think your question introduces.
Tom?
Well, to the extent, Paula, that your question is about the president as opposed to presidential, I would just like to observe that there are probably 30 million more Americans who now know about trade law than they did before. So it's all good.
And here at the Scholl Chair, we're doing our best to increase that number. Yes, sir.
Hi there. I'm best known as Tom and Deanna's law partner, but my name is Jim Aducey. And as you know, historically and currently, 90% plus of 337 cases are based on allegations of patent infringement, yet the jurisdiction of the Commission extends to many other types of unfair acts and methods of competition. So the question is, looking down the road, do you predict that there will be an increase in the number of non-patent-based cases? And if so, which unfair acts present the best candidates?
I would think U.S. Steel might be a deterrent to that, but who wants to?
Well, I mean, one area that clearly became of greater interest was trade secrets. The case I mentioned earlier kind of opened the door even wider to complainants coming to the ITC with trade secret cases. But I think the other half of that equation is that, as we've all learned and been reading, patentees are having a much more difficult time not only defending their patents, but asserting their patents. And there are an awful lot of counselors out there who are counseling people to protect their intellectual property as trade secrets as opposed to patents. So I would say that certainly trade secrets is an area that is going to get more exposure at the ITC, as it already has to a certain extent.
Yeah.
I agree with that in terms of trade secrets, and as I guess some perceive patent protection or the value of patents has gone down, they've gone to trade secrets, and that is an area where the Commission has had several cases, including having them upheld at the Federal Circuit. With respect to antitrust, the Commission just instituted another case based on antitrust post the decision that came out on steel. So, I mean, I do think the Commission was helpful in clarifying what they thought the statute required. So we'll see how that goes. And there are other unfair acts. Lanham Act case, the Lanham Act cases have been successful, and that's another area of false advertising. So I think there are a number of them. Going back to the small business part, if you have counterfeits or trademark issues, I think there's always a balance between can you get effective relief at the border? Do you need to go get something in hand which helps you with these online retailers? So I think that's kind of part of the mix of cases that are going to be up there. So.
Okay, question over here.
Hi there, Jordan Kahn, Embassy of Canada on the trade policy team. As more of an outsider, I suppose, I'd be interested to know to what extent you see or foresee the current administration's focus on enforcement impacting the activities under 337.
Somebody?
I think it's helpful, right? I mean, if as a practitioner now, and you want to say, do you think you have a case where the president is likely to, at the end, turn it down the way the way of the Samsung Apple case? I think you could. I feel pretty comfortable saying, no, this seems to be a very pro-enforcement president. And so he's going to enforce this statute the way he's enforcing statutes that we haven't heard of for 10 or 12 years. So I think it's good for enforcement.
Okay, right there.
Thanks. John Mullen, McClarty Associates. Tom, well done. It felt as if we were back in law school. Bill, you started by talking about China, and we haven't really talked about China, but the question here is defending intellectual property. Is Section 337 the right answer? Obviously, 337 is an answer, but the administration is employing a lot of other trade remedies. I wonder if you could, and the panel could talk about that a bit.
Anybody want to? I mean, I can do that, but go ahead. Tom, you want to say something?
Just a very brief answer to the point. When I started practicing in this field, the cases were against Europeans, the British, the Swedes, the Danes, everybody was infringing and bringing unfairly imported goods into the United States. And then over time, of course, that pendulum has swung in an eastwardly direction. There was Taiwan, there was Hong Kong, there's been Korea, there's been Japan, and now there is China. And I would submit that China is not going to be the end of the story. I think that pendulum is going to continue to swing. I think the Chinese have, through their own intellectual property laws, have come to understand the value of intellectual property. My sense is, I'm not a student of what goes on in China, my sense is that they are enforcing intellectual property rights better within the country, and I think to that extent, Section 337 is going to have fewer Chinese customers than it's had in the past, but I think the statute has had an impact on the way Chinese companies trade in the United States.
So I'm not going to disagree with my partner, but I am going to say that is all true. I mean, I agree with everything he said, but if you just look at the sheer volume of imported goods that infringe, and the most recent statistics that I looked at, products from China accounted for more than 3/4 of the value of all infringing and counterfeit products seized by U.S. Customs. So there's clearly still a very big issue, and I think we need all our tools. And so, Section 337 only works if you have a valid domestic industry and you've got a valid IP right. 201, is a safeguard. You got to have the volumes to get to the ITC. It's not based on IP rights. 301 is aimed at a much different set of practices. So again, I think in the toolbox that a trade lawyer or an IP lawyer has to present to clients, I do think you have to be a little broader. And I do like, I think it's something that Katherine and their team is looking at, which is, I used to think it was like there are a lot of IP lawyers out there and there are trade lawyers, and they don't really talk to each other, even though it is so interconnected now. And I think that's what might be the next horizon that we have to get to, which is when so much of trade is cross-data or cross-border data flows and 3D printing and the things that we've touched on, you might need an additional tool beyond what we have today that's workable.
I would just add, I think this president's preference seems to be for tools that are where the timeline is certainly more limited and also flexible, and where he's the decision maker. He's not been as interested in quasi-judicial processes, which the administration would not generally initiate, but a private party would initiate, and then he may have a say in the ultimate outcome, as was in the case where Obama made a decision last year. But for the most part, he's reacting, not leading. His use of 232 and 301 suggests he prefers a process where his administration takes the initiative and where he makes the decision. And I suspect you're probably going to see more of that. Yeah, on the right here in the row, on the aisle. Thank you.
Yes, just wanted if you could elaborate a little bit more about the caseload issue.
About what issue?
Caseloads.
Caseload. Anybody?
I don't know if you have a specific question. I mean, one thing that I don't know if you're aware of and that I think is a great thing that the Commission has done, which is the ITC on its website. If you go on the ITC website and go under intellectual property and statistics, you can see, they track it. So they show you how many cases, what the caseload's been over, I think, the past 5 years, how many non-practicing entities are, what the settlement rate is, what the violation rate is. So there's a lot of information, and including, the ITC does a budget for Congress, and they include kind of workload and workload projections. So, by their own estimate, this was the Commission's budget justification for 2019. They're showing a 2018 estimate of 70 to be instituted, 62 to be completed, and for 2019, 60 to be instituted. So they show a slight decrease, but again, I think they know that the private parties depend, that's the private parties, they don't usually institute their own. So I think it's, I don't know if that's responsive to your question, but.
What is the spirit behind the loading issue? What is the intent behind it? Could you know what is the intent behind case being loaded all of a sudden?
Oh, like an increase? Yeah, so I mean, again, if you look at the data, and David, I think you did some looking at this as well, I mean, it's not a huge increase, right? There was a tick up in 2011, and then it kind of leveled off, and then the last couple of years, so in 2015, for instance, there were 47 cases instituted. In 2016, there were 79. And 2017, 64. Does that sound right? So again, some of the things we talked about here, increase in trade, the post.
There's some Supreme Court decisions
Supreme
which
Court,
I think have contributed
Heartland.
to the increase of TC Heartland, eBay, cases
Yeah.
like that have increased the case.
Okay, we had a couple in, one way in the back there, second to last row, right there. Thank you, Jonathan.
Good morning, Warren Payne from Mayor Brown. I want to ask a question on something Mr. Schaumberg started to cover in his initial presentation. And that is, he noted the AIA created the IPR process. And so we've had the passage of time now, and we've had a few cases at least where a patent in a 337 investigation has been subject to an IPR. And as Mr. Schaumberg noted, the commission is generally not deferred to the decision coming out of the PTAB. So I have a two-part question. I'd like to hear from the panel on whether you think that's the right approach, that the commission should not defer to the PTAB decision. And if you believe that, what are the long-term ramifications if over time we start to see more, for lack of a better term, split decision, where the commission is enforcing an exclusion order on a patent that the IPR process is found to be invalid?
Who wants to go first? Ben?
I think the state of play on that issue is unsettled. There have been some recent decisions in the 945 case. It's a modification proceeding involving Cisco and Arista. If I'm recalling the decisions correctly, which just were very recent, there was some views which can be read to come out on both sides, depending on various patents and where they were in the appeal process, things of that nature. So I guess where I am is I think things are unsettled, and clarification or guidance from either the Federal Circuit or perhaps the full commission might give the parties some certainty as to the impact PTAB decisions can and should have on ITC proceedings.
I guess and I'll just note that I'm involved in those cases, so I will preface my remarks with that I actually think the Commission has gotten it just right. But I think the Commission, in doing so, is looking to both its own, what its statute says, what it's supposed to evaluate when a stay is requested, and has given itself flexibility. So there are particular fact patterns where the Commission may or may not stay a future case. But it doesn't bother me, having been at the Commission, to say, we're told to do this, and we're told to do it in the earliest practical time, and until the patent is actually canceled, because you still have appellate rights, right? Until it's actually canceled, the Commission would be second-guessing, relying on statistics, which were some of the arguments made. Well, yes, the PTAB, even before it was invalidated, they were making the same arguments. Of course the PTAB is going to invalidate, because the PTAB invalidates 70% of these IPRs. And I don't think the Commission should be in that business. So I think the Commission should be in the business of, what's actually happened, what's the facts, and what can you, what are you arguing under the particular state factors.
Okay, we have time for one more, and right here gets the last question.
Hi, I'm Joseph Ahn. I'm economic policy at the OMB. And I was kind of wanted to go back to the trade secret question. And I think the flip side of that is prior user rights, which is, possibly becoming a more popular defense. And I'm wondering, if the panel has an opinion on, prior user rights and, whether that should be recognized also internationally.
To the extent that I understand it, prior user rights are an element of the law. You do take a bit of a chance not going for the patent and instead relying on trade secrets. But I think if you look at it, whether it's domestically or in connection with the import, if there was in fact prior use of the trade secrets, I know this has come up in some of the ITC cases where the argument was we did not misappropriate trade secrets. We were actually using the same concept. The Commission is certainly capable, and the judges are certainly capable of making that decision. So I think the Commission would credit prior user rights as much as a district court would, if that answers your question.
Okay, anybody else want to chime in on this one? Okay, we're beyond the point, so I'm going to ask you first to thank the panel, if you would. And thank you all, and just thank you all for coming, and just a reminder that once our paper is finished, we'll be sending it to you, and we would welcome comments on it at that time. Thanks again.